All right. Hello, everyone, and to our many guests online, many participants online. Welcome to the Public Law Seminar Series, the first of this term 2 here at UCL. The Public Law Seminar Series is the rebranded version of our old friend, the Public Law Group seminars. And the Public Law Group has now become part of the Global Centre for Democratic Constitutionalism, which is a new center here at UCL, funded by the Labor Human Trust, that is committed to advancing scholarly knowledge on democratic government and the rule of law, as well as we hope and intend to produce leading research on the conditions and pathways for constitutional resilience in electorally competitive political systems. Those of you interested, please sign up for our newsletter. Our website will be going live soon, and we will have more events this term and next. So I'm Erin Delaney. I'm the director of the center and professor of comparative constitutional law here at UCL. And it is my great pleasure to introduce a man who really needs no introduction, and I could have had 4 or 5 pages worth. So I will be short. The great Paul Craig, emeritus professor of English law from the University of Oxford. Some of us are his PhD, we're his PhD students in the room, so I know many of you know him well. His research interests are extensive. His leading works are numerous and influential. He's a fellow of more things than you can shake a stick at, including the British Academy and Honorary King's Council. And he has written a magnificent tome, English Administrative Law from 1550, Continuity and Change, published by OUP. I don't have the hard copy here to hold up for the product placement, but maybe Paul, you will do so, or Tom. So get a copy yourself or at a library near you. He will open with about 15 minutes of commentary on the book, and then we will turn to commentators and have, I hope, ample time for robust conversation. So thank you very much. The floor is yours.
Erin, thank you so much, and thank you, Jeff and Tom and UCL for hosting this seminar. So I'm going to speak for about 15 minutes and just give you an overview of the architecture of the book and what the book's trying to do and some of the things that I learned while writing the book. So the book is divided into 4 parts, and I'm going to say a little bit about each of those 4 parts of the work. The first part, called Perception and Reality, was sent round to everybody who wanted a copy, and so you have a copy of that, and I won't dwell on it too long. But of course, not everyone may have had a chance to read it, so let me at least touch base with that, because if you don't touch base with that and you have no idea of what the central thesis is, then the stuff which comes thereafter isn't going to make so much sense. So, perception and reality. Very quickly, standard perception of English administrative law is that it didn't exist until the mid-20th century. Maybe some people might venture back rather adventurously to the late 19th century. And that view is associated most notably with Dicey, but it's the view which was taken by most, the great majority of modern public lawyers as well. I argue in the first chapter of the book that that view is based on 4 assumptions. There are empirical and normative assumptions about case law and empirical and normative assumptions about regulation. Very briefly, once again, because of exigencies of time, I'm not going to focus on the normative assumptions because of limits of time, but I'm very happy to answer any questions about the normative dimension in the Q&A. Just focusing for the moment on the empirical dimension, I have told generations of students and colleagues that I'm a very simple person, and I am, and I like my doctrine, or I like my theories to be as simple as possible, and this one really is simple. So the empirical assumption behind the Dyson et al. View is that we didn't have administrative law judged by two criteria, empirical criteria. There was very little case law, excuse me, and there was very little case law because we didn't need it, because there was very little in the form of regulation or administration. That is the CNN soundbite view of the perceived view of administrative law. So the idea is there wasn't a history. You can't write a history on something which doesn't exist. And on their view, it didn't exist. Okay? So that's the empirical dimension to the perceived view. It's all explained in much more detail. And I've only got 15 minutes, remember. The reality is quite the contrary. We have had since 1550, with earlier origins, we have had a very vibrant, detailed case law on administrative law. And we have had that because we have had a whole ton of regulatory legislation and administration from the 1550s onwards. Quite simple. You have administrative law because you have regulation and administration. Really simple. Doesn't get much simpler than that, but it's undoubtedly true. So, what I say in the first chapter is that if the great judges from the 17th, 18th, and 19th century, if you took Cook and Holt and Mansfield and Blackburn and Blackstone and Coleridge and Colburn, and if they were to look down the table of contents of a modern administrative law book, they would shrug, or do whatever judges from that time did. They would shrug and say, so, yeah, that's fine. I mean, we created all of this. What have you been doing in the meantime? And they did. Okay, they did. They created it. So, part 2 is regulation and administration. 6 chapters. 6 chapters. It's a monograph, if you like, within the book. It's sometimes people in Oxford are accused of only being interested in judicial review. That has never been the case with me. Every book I've ever written about administrative law, either in the UK or the EU, has at least a third of the chapters about the administrative system. This book is no different. 6 chapters out of 22, over 200 pages, are about regulation and administration. How does it break down? 2 chapters on the regulatory state, chapters 2 and 3. What is and they are vertical and horizontal. Vertical meaning chapter 2 makes good on the claims in chapter 1. What chapter 2 does is to say, I have told you that there was a very great deal of regulatory legislation, which is why we have administrative law. I'm now going to take you through, excuse me, the different subject matter areas in which regulatory legislation existed. That's what I do. Chapter 2 is an A to Z guide. There are 12 different types, 12 different sections dealing with the different areas in which regulatory legislation was made, including excise, including enclosures, including the poor law, including municipal government, including public health, including police measures, you name it. I divided into 12 sections. A number of those sections have subdivisions. I'm doing it for didactic ease. If you really break it down, we're talking about 25 different substantive areas in which regulatory legislation existed. The Tudors, the Stuarts, the Hanoverians, and the Victorians regulated in spades. Okay? The idea that regulation is modern is nonsense. This, I want to emphasize, was formal law. I'm not talking about soft law, I'm talking about statute every time. Chapter 3 develops that by looking horizontally, saying, okay, how was the legislation made? Who made it? What was the input? What was the output? And I also have a section showing the importance or relative importance of different primary theories, mercantilism, free trade, and utilitarianism on the regulatory landscape. Let me put a figure in front of you now, because sometimes figures are helpful, sometimes they're not, sometimes they are. When I tell people that we've lost sight of the regulatory landscape and the statutes, people nod a bit and they think, okay, well, we missed a few. We missed a few of these statutes. Okay, let me clarify. Julian Hoppick, a historian, calculated that between 1688 and 1800, 112 years out of my 350 years, 112 years, 13,600 statutes. Okay? Out of those statutes, at the very least, a half, and that's being unbelievably conservative, were public law regulatory statutes. It's more. If you take the whole period, fewer statutes per year prior 1688, actually more after 1800. If you take the whole period, at a very conservative estimate, we are talking about in excess of 10,000 regulatory statutes. Many of these were local. They were about an improvement commissioner's powers to run Birmingham or Oxford or indeed the City of London, things of that kind. But they were nonetheless formal statutes, incredibly important in people's lives. Next two chapters were concerned with the administrative state, vertical and horizontal. 2 chapters after that are concerned, were really exciting to do. They were concerned with the administrative state, decision-making and rule-making on the one hand, and then the administrative state contract on the other. Bottom line here is, how does the administration discharge its duties? The answer is the same in 1550 as in 2025. It can make individual decisions, it can make rules, or it can make contracts. And they did all 3 from that time onwards. With respect, we know almost nothing, or we knew almost nothing about rulemaking capacity and contractual capacity of administrative authorities before I kind of wrote these chapters. They were really exciting to do. I've only got a few minutes, so let me move on. Part 3 of the book is called Court and Doctrine. And in the part 3, it has 9 chapters. 1 chapter about foundations, then a chapter on natural justice, a chapter on jurisdiction and review of law and fact, then a chapter on rights, followed by a chapter on delegation, fettering and purpose, a chapter on reasonableness review, a chapter on proportionability review, yes, it existed, and a chapter on review of the prerogative, and a chapter on review of third source power. So all of these heads of review were created by the courts, and I elaborate in detail on the jurisprudence of the courts in each of those chapters. What was fascinating was this. Many things were fascinating. One of the things which was completely fascinating was and this is fascinating about doing legal history. When you go back and you do legal history, you go back and back and back. And of course, we're used to reasoning by precedent. It's what the common law does. But you go back and back and back, and there's a beginning. There isn't a precedent. They're making it up. They're creating it from first principles. And one of the fascinating things about doing legal history is you watch them create it from first principle. Part 4, remedies and review, 6 chapters. A chapter on invalidity, a chapter on standing, a chapter on the prerogative writs, a chapter on declaration, injunction, quo warranto, and habeas corpus, a chapter on the application of tortious and restitutionary principles to public bodies, and then an epilogue. Very briefly, again, amazing here watching both the creativity of the common law. I mean, just very briefly, look, we all think about the prerogative writs. We all know we have certiorari, we have mandamus, we have prohibition. And of course, they're prerogative writs, and they meaning that they had initially issued from the king in the king's name as commands. But actually, the transference and creation of those writs into public law remedies of the kind that we have nowadays didn't happen by itself. It wasn't preordained, and it wasn't inevitable. It happened because of the creativity of the courts. And the courts sometimes, this is not a Whig version of history. There are many instances here in this book where I'm critical of what the courts have done. I take them to task and I say that really didn't make any sense, etc. Thus was it ever so. All institutions are imperfect. But nonetheless, they created a body of remedial jurisprudence which was fit for the emerging administrative law system at the time. Thank you very much.
Thank you very much. It is my pleasure to turn to my colleague, Professor Jack King, who will be the first to respond to the book.
Thank you, Erin, and thank you, Paul. So it's a privilege to comment on Professor Craig's book today and to host him here at UCL. For those that don't know, Paul was my DPhil supervisor in Oxford some moons ago. He was my academic mentor for many years and a good friend ever since. About 5 years ago, I helped organize a conference that celebrated Paul's career and distinguished contribution to law. And we published a book called Foundations and Future of Public Law, which was a collection of essays in his honor. And I can tell you the range of contributors to that book and how easy it was to have them agree to come across Europe or from the Supreme Court to participate in that conference and to contribute to that book was a testament to Paul's contribution to our subject here in the UK as well as across the EU. So I'll say a few words about the book. I want to put the book in context about discussions about the legitimacy of the administrative state, and then raise a query to Paul, sort of a suggestion of accounting for what looks outwardly to be a step change in the development of the administrative state in the 20th century. So the aim of the book, as we've just heard very clearly, is to unsettle the idea that was propagated by Dicey that the UK had no administrative law prior to the 20th century. And in my comments today, I'm going to focus on part 2 of the book, which is the other reason that I'm speaking first. That's the part that addresses regulation and administration. It's primarily about the origins of the regulatory and administrative state in England and later Britain. The book demonstrates across 6 chapters the existence of proto-features of the administrative state. Now, for some readers, this could be dry territory, although as Paul knows, definitely not for me. This explores the role of the state in regulating bankruptcy, trade in goods like wool and cloth and leather, customs and duties, regulation of prices and wages, flood defenses, public health, disease, regulation of the factories, and the creation of municipal improvements, protecting against things like floods and so on. Now, for some, this doesn't have quite the same flash appeal as the 17th century jurisprudence of Sir Edward Coke. Did you call him? I've been calling him Coke for the last 2 decades. Where those pockets of where these became classic showdowns between king and the judges, various kings. However, what is interesting in this book is that in chapter 6, Paul explains how these pockets of regulation and administration he's been discussing relate to the evolution of the core institutions of the executive branch of the state, and indeed the parliament itself. Hence, he traces the growth of the executive from kingship through the Privy Council and the Cabinet Council and into the modern day cabinet that's located in the House of Commons. And in so doing, he examines the legal architecture of regulation and administration in all of these areas. And I notice the cover of the book is actually it's a painting of Westminster Hall in the UK Parliament. So it's not a classic wave text about how judges defended our ancient liberties. Now I'll step back from the detail in a moment to those themes I mentioned, but I wanted to state the primary contribution of the core argument as I see it as well. So in all of the areas that I've mentioned, the key claim is that there were statutory frameworks that put into place new administrative powers. They set in motion systems of regulation, which included coercive powers to intervene in property rights, impose conditions, levy fines, and in many cases to issue new rules that had legislative character or were simply legislation. And the power of those bodies were all subject to the control of the courts of law. And there was a much more than marginal amount of case law created in scrutinizing the exercise of those powers. That was the birth of administrative law of a both statutory and judicial character, and it dates to at least halfway through the 16th century. Now, why is it so important to put this argument out at the present time? I'll say a few words about this. It's important for several reasons. First, it's an insufficiently explored facet of the constitutional history of this country. And by extension, it's a lesson on the relationship between the common law and administration that goes back nearly 500 years. It refutes a thesis that was popularized by Dicey and those who followed him, those who hold on to what Paul calls the conventional view in chapter 1. And I think most importantly, the book comes into conflict, or it contributes to, a rather shrill debate that's currently occurring in the United States about the legitimacy and constitutionality of the federal administrative state. A word about that. The Lochner era in US constitutional law on the standard account dates from the Lochner v. New York judgment in 1905 to the West Coast Hotel Co. in Paris in 1937. Between those 2 dates, hundreds of state regulatory statutes and a wide range of federal statutes as well were struck down by the US Supreme Court. However, a number of US jurists presently are encouraged in meetings of the Federalist Society and in many scholarly discussions, are putting neo-Lochnerian arguments forward at the moment to challenge the administrative state. To see a discussion of those, you could have regard to the article by Gillian Metzger called 1930s Redux, the Administrative State Under Siege. It's a forward to the Harvard Law Review a few years ago. There have also been a series of US Supreme Court judgments in the last 5 years where the acceptance of the administrative state has been fundamentally challenged, and where a range of new avenues for judicial obstruction of agency action have been created through the overturning of old rules, such as the Chevron deference standard and the introduction of a new kind of version of the non-delegation doctrine, the major questions doctrine. Now, one line of scholarly inquiry that promoted that view, which is being consolidated as we speak in the Supreme Court, was a book by Professor Philip Hamburger, Is Administrative Law Unlawful? Hamburger's answer is basically yes, because US administrative law locates the historical precedents for the American federal administrative state in a range of legally unregulated prerogative powers in the Old English Constitution. And he also contends the very thesis that Paul's book refutes, that administrative law was a novel development, and that Dicey was right. Now, my understanding, Paul, is that you had been engaged in dialogue with Hamburger about this very question, and you had told him he was wrong. And this book looks like the definitive refutation of his view. So the US discussion, I think, could do with this book very much. However, I want to make a point about one important difference between the US and the UK discussion. Although Hamburger is the one that tries to bring them together, there is an important difference. The US federal government and the office of the presidency in particular is not only quite limited in its enumerated powers, but powers not delegated to the federal government are reserved to the states or the people under the 10th Amendment. Now the effect of that is to create a set of arguments about the nature of US federal authority that can make the discussion quite rarefied, quite text dependent, quite unlike the largely undoubted plenary legislative power that we have under the Westminster Parliament. In other words, you start with the idea of a limited federal government in the United States, and you have to defend in arguments with people like Hamburger against the idea that you can read those words to supply the kind of federal power that no one doubts that the Westminster Parliament has. So I think also the US Constitution is unlike many other constitutions globally, because most of these other constitutions were written in the 20th century, and they provide directly for the creation of an administrative and social state. Let me move on then to Paul's historical thesis in the book about the regulatory and the administrative state. And I'd like to put up a point for discussion and hear your thoughts about this, Paul. And the point is this: could one not argue that while you have clearly demonstrated that there were embryonic, at least possibly quite developed features of the regulatory and administrative state dating back to the 1550s, and possibly even earlier, as Elton's work on Tudor government history, could we not still argue that what occurs in the late 19th and early 20th centuries is of a difference of scale that warrants treating them like a revolution and not simply an evolution? Was there not a step change at that point in time that might provide some oxygen for those theories you're refuting? Now, on the point of scale, the discussion recognizes the absence of a sizable centralized administrative branch of government that administered the regulatory schemes that are discussed. At the center for all of these regulatory schemes and customs and excise, flood defense, and so on, you have the role of the commissioner. And all of these commissioners were people that were appointed by government to ad hoc offices. They were the ones that exercised these regulatory powers. They were like justices of peace. They were typically influential private citizens and property holders, not normally permanent public officials. Now, you have a quite frank discussion of this type of issue on page 145, where you say, quote, "The resort to commissioners was in reality an admixture of contracting out and co-optation." The point here being that the state either gave them stuff to do or it brought them in temporarily to do stuff. And you go on to explain that this reflected the duality latent in the term commission, which captured something sought and something granted. And then you add that, quote, "The tasks could not be performed from the center, and systematic central oversight was implausible. The brief experiment with centralized bankruptcy administration lasts about 30 years. And you add, "This was unsurprising, given that in 1797, the Home Department had a staff of 26, Foreign Department a staff of 24, and the Audit Office a staff of 23. All of that being roughly a quarter of what the staff at the Faculty of Laws at UCL presently has." So I think staff sizes like this are in fact a proxy or an indication of the size of some branch of the administrative state. And I found an interesting website of numbers on the civil service website. I was interested in this. So you discussed the Northcott Prevailing Report, which was instrumental in creating an independent civil service in the UK. And they noted in that report in 1854 that the number of civil servants was around 16,000. By 1902, there were about 50,000. And by the time of the Tomlin Royal Commission of 1929, they reported there were about 424,000 civil servants. So from 16,000 to 424,000 at a time when the population hadn't doubled. And then by the end of World War II, the number was nearly 1.2 million civil servants. The numbers increased very radically during both wars. In fact, there's a famous quote by Winston Churchill that World War I was the greatest case for state socialism ever made. He was the minister for the most active department at the time. So my sense here is that there was a step change in the scale of the administrative state. I think that the report of the Donnemore Committee on Ministers' Powers in 1931 is sort of premised on recognition of that step change. They deal with the advent of delegated powers. And that report is quite critical of a book popularized by Viscount Heward called The New Despotism. It was published in the early 20s. The committee had a response to that book, which was actually would credit many of the arguments in Paul's book. At the same time, though, the committee its convening was premised on the acceptance that modern administration had changed. The question was whether something needed to be done about it, and if so, what? So in the report of the committee, they cite a discussion in Cecil Carr's lectures on delegated legislation. Cecil Carr was responsible for producing revised annotations of statutes, and in particular about orders and rules, and was an incredibly learned, practical, jobbing lawyer at the time. And Paul's work discusses Carr, and he was very important to the Donnemore Committee. They took his book seriously, and they had him in for oral evidence. And in one passage in Carr's lectures, which is quoted in the Donnemore Committee report, Carr observes he takes 2 years, 1819 and 1820, and he summarizes all of the legislative delegations in those years in the space of one paragraph. And he says that the rest of the lawmaking that was needed on an ad hoc basis was done by Parliament because they could do that at the time. Now, to compare to today, a delegated powers memorandum produced for a bill in Parliament will on average be between 25 and anywhere to 50 or 60 pages for one bill. So the point Carr had was that in those days, a Parliament could regulate much of the detail, but his deeper point was, and consonant with, I think, some of what motivates Paul, that there had been enormous social and political development in the modern industrial and democratic period, which required a different and more active regulatory and administrative state. And the core feature of that was delegation of legislative powers so that they could regulate on questions such as lamps on miners' hats, is one of the examples he gives. So my question for you, Paul, is whether you recognize such a transformation, or do you deny that there was something very novel? And if you recognize it, my question then is that does the continuity thesis and the emphasis you place on it in some ways downplay the significance of that transformation? I'll stop there. Thank you.
Thank you very much, Jack. And now I turn to my other colleague, Tom Hickman, who's a professor of public law here and a KC at Blackstone Chambers, to respond for part 3.
Thanks. Yes, that's right. Thank you very much. Let me also begin by just making a few remarks about Paul Craig, because I think it's entirely warranted. It's fair to say Paul has been a huge influence on myself, as he knows, but also he, I think, is the academic that is most influential to practicing barristers, because his work is so accessible and it's so relevant to the sorts of issues that practicing barristers and solicitors are dealing with. And testament to that is the number of times that his work has been cited by the courts, which must be more than any other public lawyer. The book is extremely impressive. It displays all of the clarity and rigor of analysis that we associate with Paul's work. And it's obviously, as you've heard, the breadth of it is huge. But it is, I think, an argument, first and foremost, That is to say, it's not reaching back into history and simply providing a descriptive account. The book to me reads very much as an argument. The argument you've heard Paul describe today is one that attacks and seeks to undermine what he presents as the commonly held view of English administrative law, that it is of recent origin and principally the product of judicial innovations in the second half of the 20th century. Nothing that could be described, he says, as administrative law is thought to have existed before this time, perhaps a bit earlier. Now, Paul Craig's works on administrative law, his textbooks, famous textbook on administrative law, always looks beyond judicial review, as he's explained himself. There's always an institutional segment of the work, and this book is in that tradition. And in effect, what this book does is it takes Paul's textbook on administrative law and the structure of that textbook, and it takes each of the sections, slightly adjusted of course, but each of the sections of the themes, and tries to push the underlying materials back 400 years. So no, that's not a modest ambition, whether it's doctrine or it's the institutional framework, contracting out and so forth. And that seems to me to be the basic methodology of the book. Now, Paul spoke a little bit about the first chapter of part 1, Jeff part 2. I'm going to focus on part 3 and a little bit on part 4, which is about remedies. Some of this, the analysis of remedies and the effort to push back the historical foundations several hundred years, is actually quite familiar to public lawyers. So textbook and other discussions of various of the doctrines of public law commonly trace the principles, for instance, of natural justice and the probative writs, back to cases such as James Bagg's case in 1615. Now, Bagg's case, you will recall, for those of you who studied administrative law, has some amusing facts that are worth retelling. And around this time, there were about 150 towns and townships that were self-governing boroughs. And a row that broke out between the borough alderman James Bagg and the mayor. And as recorded in the report, Bagg turned his hinder part in an inhuman manner towards the mayor and scoffingly told him to go kiss. He was removed from his position. The King's Bench nonetheless ordered that Bagg be reinstated, as he had not been heard in his defence. Before this case, the King's Bench had afforded only a remedy for what was called restitution. I wonder if anyone's dares push the law of restitution back to James Bagg's case. But what was meant here is that the office holders could be restored to their office if they had the temerity to approach the King's, if they had the temerity to challenge the fact that their dismissal is related to them approaching the central courts rather than the borough courts. And it didn't really go beyond that, but could, in that case, transform the law and the writ of mandamus. And one recent study notes that by the mid-17th century, so that's well over a century later, because of Bagg's case, the King's Bench jurisdiction to remedy borough corporate maladministration was flourishing. So it was a transformative case, both for the writ of mandamus, but also for the doctrine of natural justice. But that is a case that we're all familiar with from the textbooks. Other areas of inquiry are more original, and originality brings controversy. There are sections of the book on the principle of reasonableness. The argument is that the requirement for statutory discretion to be exercised reasonably can be pushed back to the 16th century. Now, I am very sympathetic to this argument, and I think it's correct. I argued myself a very long time ago that the principle could be pushed back to a case called Leader and Moxon, in which a paving commissioner or paving commissioners built up the pavement outside someone's house so that it stretched 6 foot above their door. And the court said that their discretion could not be exercised in a way which buried people's houses underground. Paul Craig pushes the principle back about another 100 years. But where I part company with Paul is in relation to at least the principle of proportionality. His argument is that, and I'll quote, from the 16th century onwards, England had a concept akin to that of proportionality. Now, the principle of proportionality is still not a freestanding principle of public law. Its application has to be triggered by human rights engagement or some other trigger principle. And so what we have here, I think, is avant-garde public law from Paul becoming avant-garde legal history. Public lawyers are familiar with some historic instances of courts quashing disproportionate conduct, such as Lord Denning in Hook's case. You will recall that is the case of the market trader who was banned for life after he was caught relieving himself down a side street after market hours. You will note I'm trying to accrete all of the most amusing public law cases. It is worth quoting Lord Denning. He said, "Now there are old cases which show that the court can interfere by certiorari if a punishment is altogether excessive and out of proportion to the occasion. In one case, the Commissioner of Sewers imposed an excessive fine, and it was quashed by the Court of King's Bench." It was a case of 1951. So in this case, if Mr. Hook did misbehave, I should have thought the right thing would have been to take him before the magistrates under the bylaws when some small fine might have been inflicted. It is quite wrong that the Barnsley Corporation should inflict upon him the grave penalty of depriving him of his livelihood. Now, Paul Craig traces the principle much further, indeed to Elizabethan times, and points to cases under the Statute of Sewers 1531, and in particular Rook's case of 1598. In that case, the Commissioner of Sewers again levied a charge for repair of riverbanks. And in this and subsequent cases, the Court of Common Pleas and the King's Bench held that those who benefited from the charges to repair riverbanks should be assessed and taxed according to the benefit that accrued to them. Now, Paul finds in this case, in this line of cases, the principle of proportionality. I confess to being sceptical. The reasoning of the court in Rook's case was, and I quote from the report, "The Commission of Sewers is formed and specified as precise words in the said commission, and no person, any estate or condition shall be spared." In that case, the issue was that they were focusing on taxing one particular person who happened to be the closest to the river. And the court derives the principle that everyone shall be assessed in proportion to the benefit from the words of the commission itself. Now, of course, they did associate this with principles of equity, and they said that this cohered with an equitable approach to fulfilling the commission's requirements. But I do think it's a bit of a stretch to find here anything really that relates to the modern principle of proportionality. Of course, public power has always been conditioned by reason, at least where matters of justice and claims could be brought before the courts. But I am unconvinced that a doctrine of proportionality deserving of the name, certainly chapter of the book, is to be found before the second half of the 20th century, and then only in limited contexts. There were, of course, odd references to things being proportional or proportionate in the case law, but these were, I think, limited and can't really be joined up into a coherent doctrine. The manner of reading historic precedents, as well as the overall approach of taking the modern doctrinal landscape, as it were, framework for analysing the historical sources, will undoubtedly, I think, give rise to some criticisms of the work as being weakness. And what I mean by that is in particular the idea that a modern framework can be imposed on a dissimilar historical epoch. Now, Paul is alive to this, and he addresses it in various places throughout the work, and indeed has mentioned it today, and is careful and nuanced throughout to make sure that his treatment of specific cases is accurate and historical, although, as I've indicated, I would challenge some of the analysis on this basis. Moving on to a question in particular, I mean, I've challenged and pushed back a little bit at some of Paul's fantastic work, but now a more particular question. And this actually chimes with the question that Jeff was asking. I wondered about the true nature of the disagreements with what is characterised as the dominant assumption of modern public law scholarship. I had a look, for example, in Wade and Forsyth, one of the leading textbooks on administrative law, and they say, pages 10 and 11, I quote, administrative law in England has a long history. Subject of its modern form did not begin to emerge until the second half of the 17th century. Wasn't there? That's quite a lot further back than the second half of the 20th century. A number of its basic rules can be dated back to that period, and some, such as the principles of natural justice, are still older. Up to about the end of the 19th century, administrative law kept pace with the expanding state. In the 20th century, yeah, Paul talks about the famous comments in original Lord Reed, where he says that up until that point, England had no developed system of administrative law. But I would emphasise that comment of Lord Reed's was talking about a developed system of administrative law. And there are many other cases where courts around that time, a little bit later, talk about the development of administrative law. The ex parte Bennett case, in which Lord Griffiths says, talks about the great growth of administrative law during the latter part of the 20th century. In cases such as Bill Secures, which sought to address the developed system of administrative law in the context of a negligence claim against the Home Office for escaping Warsaw boys who had damaged some yachts. And Lord Dickock talked about the ultra vires principle now being the unifying principle of public law. And it seems to me that what happened in the second half of the 20th century was that there was a corpus of law developed that was general and systematic and effective at controlling modern public powers. It was not, as it were, an entirely original corpus of law. It very consciously had deep historical roots, but its key characteristics included the removal of the distinction between judicial and non-judicial acts, the liberalisation of standing, the collapse of the distinction between errors on the face of the record and other errors, the adoption, as I've mentioned, of the ultra vires principle as a unifying principle of public law doctrine, and of course the procedure in 1977 for bringing a challenge against public bodies under Order 53, which hadn't existed until that time. This looks like a modern, new approach to public law, very different from what had gone before. And I did wonder, in a similar way, I think, to Jeff, as to the extent to which Paul is really addressing a genuine disagreement with the assumption of modern public lawyers is undoubtedly the case. He's done an enormous amount for revealing the depths of administrative law, both in terms of its doctrine and in terms of the structure. I think probably particularly in terms of the structure of the administrative state. But I would welcome his thoughts on whether, in fact, the real question is to what degree the courts developed a systematic, a different form of administrative law in the 20th century, rather than that they created administrative.
So we truncated Paul's opening remarks to give him ample time in response to the discussants and to again open the conversation for the audience. So Paul, the floor is yours for 10 to 15 minutes, and then we will take questions. So have at them.
Thank you so much, Jeff and Tom, thank you very much indeed. So let me begin with the order in which the comment was given. So let me begin with Jeff. Okay, so I think I think it's quite important to clarify at the outset something which applies to both what Jeff and what Tom said, and then I'll elaborate in greater detail. Okay. So, a point of commonality in relation to both of these observations is as follows. There is no claim at any stage in my book that there has never been any change. There is no claim at any stage, at any point in my book, that everything that we have now is the same as what we had in the 19th century or the 18th century. The book is about continuity and change, and there is no claim in my book that the period between 1550 and 1900 was all the same, or the period after 1900 and in the 20th and 21st century was all the same, or indeed all different. That is not the argument at any point in my book. It is not what I say at any stage in the analysis. So I think that's quite important. I do make clear in the first chapter that continuity and change has a double signification. Make it very clear at the end. There's continuity and change between 1550 and 1900, that 350-year period. And then what I do is I say, look, I'm not giving you a history of the 20th and 21st century. I'm not purporting to do that. That's too complex. I don't have space. What I'm doing is giving you the main elements, in my view, of continuity and change in the 20th and 21st century at a conceptual, normative, empirical level, which affect the particular topic I'm talking about. So, I think that's really important because I think there's an element of commonality in both of the comments in that respect. I repeat, I am not saying that everything in the 18th century or the 21st century was the same. I'm not saying there was no continuity and change within the from 1550 to the end of 1900, or that there was no change in the 20th and 21st century. That would be absurd. That's not the claim that I am making. Nor am I making the claim that nobody has ever, nor am I making the claim with respect, Tom, that nobody has ever had any idea that there was administrative law going on in some shape, manner, or form before I wrote this book. With respect, the very first footnote in the very first chapter pays homage to existing scholarship on administrative law history. It's the very first footnote in the very first chapter, paying homage to De Smith, paying homage to Edie Henderson, paying homage to Amnon Rubinstein, paying homage to Stephen Sedgwick. Okay, so let's just make all of that clear so that my own position is made clear in that respect. So I have no problem with the fact that Wade and Forsyth would have some cognition of the fact that administrative law was around in some shape, manner, or form in earlier periods. Fine. So let me now, so having stated that, which I think is relevant to both Tom and Jeff, let me now then go back to focus on the specific points made by Jeff and Tom. So in relation to Jeff, again, developing from that point, I'm not making any claim that administration in the 18th century or the 17th century was completely not different from the administration in terms of scale, numbers, whatever, in the 20th century, making no claim of that kind at all. Indeed, part of the story in the horizontal chapter 6 about the administrative state as it develops across time is precisely to show the difference of the administrative state at different points in time. Okay, but now a couple of more specific correctives or pushbacks in terms of how much difference there was. Okay. Let me distinguish between three different features which you mentioned. Numbers, powers, and rulemaking. So numbers in terms of the numbers of civil servants, then their powers, and then the capacity of the state to do stuff through primary legislation as opposed to delegated legislation. Let me say a word about each of those in turn. Absolutely no doubt that we have more civil servants now than they had then. You know, of course we do. Let's also be clear, however, of a couple of really important things. In 1700, there were 4 million people. In 1800, I think it was 16.8. Right? So there's a relationship between population and the number of civil servants, administrators, whatever. The other thing is that when you're calibrating numbers, and I don't know the answer to the question I'm posing, except I know the importance of the question, is that if you're doing the number calibration, then what you need to do is work out what the relationship between, what would be the relationship between the number of modern civil servants per 4 million of the population. Yeah. Now, as compared to what were the total number of administrators in these different local areas, dealing with sewers, dealing with excise, dealing with enclosures, dealing with municipal improvements, etc., because they were covering the whole administrative landscape. Now, I don't know what that number is. I really do not know, but I doubt whether once you calibrate the population, and once you aggregate the total number of civil servants who actually were working in administration in these different areas, I'm not sure that it would be quite as big a difference as one imagines. So that's one point. Numbers. I'm mindful about time, so I'll speed up. Powers. Okay. One thing I'm really pretty clear about is this. Any story which tries to say that the powers of administrators, the statutory powers of administrators in the 19th and 20th century are greater in terms of the powers they're given compared to the powers of administrators in the 17th and 18th century, I find, with respect, simply unconvincing. I have read a very great number of statutes. You want to be a public lawyer, you've got to learn to love statutes. Okay? Loving statute in the 17th and 18th and 19th century is actually slightly easier. Why? Because they're more fun. Why are they more fun? Because the preambles, apart from anything else, are so terrific. You know, you get a modern preamble and it says, well, we've got to raise excellence, you know, it's terrible. Whereas, you know, in the 18th century, you've got a bankruptcy statute which says, whereas an evil stalks the land. And terrible people are doing awful mischief to the public good by taking other people's goods and not paying for them. And this is a great mischief to the public road. It's great stuff. Okay, they were very subtle. They gave really extensive powers to the administration, both powers to investigate, substantive powers to fine. One of the favorite things at the time, which can lose its attraction, I suppose, but one of the favorite things at the time was if you were recalcitrant, you got nailed to the pillory. You got nailed to a pillory by your ear and lost your ear, and then forever you walked the countryside knowing that you were a criminal, etc. They learned by doing. Statutes were not one-off. You repeatedly saw a whole series of statutes saying, okay, we passed a statute 20 years ago, this bit's working, that bit's not working. We've got to redress it. They did it time and again. They were really quite smart in their regulatory techniques, a lot smarter than we give them credit for. So, point two then is that I don't buy an argument that says the powers given to administrators were greater in the. Of course, they were dealing with more people. We had a bigger population, obvious, but I don't take the argument that they were that the powers were more extensive. Third point, really interesting, a bit about CAR, the delegated legislation. Okay, so the argument that Jeff put from Carr was that things were different. In 1919-20, Carr could tell us primary legislation could do pretty much everything. We have very little delegated legislation. We could include it all on one page. Okay? Compare and contrast 1819-20, and now when we have, as we all know, about 30 to 40 primary legislations, primary statutes, and about 2,000 SRs. Okay? Okay, here's what's wrong with this argument. And I do actually detail this in chapter 7. Carr gets it fundamentally wrong in the following sense. What lay beneath primary statute was not just a couple of bits of delegated legislation, which you could put on one page. One of the things I discovered and detailed at length in chapter 7 is that rulemaking power was given routinely in just about every single statute to the administration. It wasn't what we call formal delegated legislation. It was formal rulemaking power, which was binding. And they not only gave that power, they recognized that they needed to have accountability checks for it. So what they did was they experimented with different kinds of accountability checks. I detail that in chapter 7 as well. Okay, sometimes you have to take the rules and give them to justices of the peace to sign off. Sometimes they have to be signed off by a member of the executive. Sometimes they have to be overseen. There was participatory input. I'd set it all out. The point I'm making here is that you cannot take Carr's argument that things were so much simpler in 1819-20 because we only had this little bit of delegated legislation compared to the modern day, because there wasn't that degree of difference. What we had for 350 years was primary statutes supplemented on pretty much every occasion in every area with formal rulemaking powers. And the legislature made it clear why it's giving the rulemaking powers. They understood why the administration needed the power to make rules. I'm exceeding my time. So let me turn to let me turn to Tom. Tom, thank you. Yeah, thank you very much. Tom, thank you very much. So, certain things are not foreseeable in human existence. Certain things are. The fact that Tom wouldn't like the chapter on proportionability comes into the category of something which is foreseeable. Now, okay, I'm going to push back on this because, with respect, this is wrong. Look, I don't mind whether you agree with, I don't mind whether you like proportionality or not. I don't mind whether you think it ought to be an independent ground of review or not. That's a modern debate. Okay. What I am doing without any strength is relaying what the cases say. We had a number of cases explicitly talking the talk of proportionability. I do not claim that it's a three-part test of the modern proportionality kind. Make it absolutely clear. I say there is a commonality in the sense of proportionability was developed in order to be a control on discretionary power in order to prevent excessive burdens being placed on a particular individual. Okay? Now, the evidence for that is explicit. It's not made up. It's in the cases and in the criteria in the cases. Now, add this, and this is why I think it's so important if you're doing administrative law to be mindful of statute as well as case law. A point I made in this book, in this chapter, is that I did digital searches and I discussed the material through legislation. Now, tell me this, do you really think we shouldn't have a chapter about proportionability review when there were roughly 2,000 separate statutory criteria in separate statutes listing proportionability as a test for review in the exercise of discretionary power? Nobody, to my knowledge, thinks that judicial review is solely and only the creation of the common law. It's of course within Parliament's power to stipulate grounds of review. That's inherent within their sovereign power. And they did it time and time and time again. Now, let me add one footnote to this particular point because it's fascinating, because I learned it from John Baker. I'll come back to a point which John Baker pointed out that I've missed. I'll come back to that in a moment. But let me put 2 and 2 together and make 4. John Baker, in some of his work, had pointed out, he looked at Wilkes's case, which is the origin of reasoning solution. And he pointed out quite often, just to make clear to people, when you look at the English report, you can get a case reported, and sometimes there can be more than one version of the report. Okay, fine. Normally, I actually read both the 2 or 3 for some reason. Don't ask me why. The imperfections of human nature or my human nature or whatever. I didn't read the second one on Richard's case. Anyway, John Baker, in a piece I hadn't looked at before, he told me about it. John Baker, great legal historian, wonderful man. He pointed out that if you look at the two versions of Rich's case, what's happening is that Cook, Chief Justice Cook, is instantiating reasonableness review, but he's not quite clear how he should be framing the test of reasonableness. And if you look at the two reports, the tensions as to exactly how it should be framed were apparently evident. Okay. Cook gave the judgment in Hickman and Boyer, which was the foundation for proportionality review. Another case about commissioners for sewers, about 10 years after Root's case. So, that's what I discovered proportionality. But I think what happened is this, and of course, we don't know, but it's not a bad guess. I think what happened is that Cook was clear he wanted some control over discretion, right? He's clear he wants some control over discretion. He's fighting to try and find a framework, criteria, which he's happy with. He then thinks, so he's got these, two different versions in two different reports on Root's case. I think that what happens is he thinks, actually, a more, believe it or not, workable test for this kind of case is proportionality, which was actually then given further sophistication in subsequent cases concerning commissioners of sewers, and further sophistication in lots of cases which have nothing to do with sewers, or the statute of sewers. So, look, I don't think in any way I'm being presentist about this. To the contrary, historians, just to make clear, legal historians, you always have to be careful that you're not being presentist, you're not leaving assumptions from now and taking them back into the past. All I'm saying is I don't think I was doing that at all. I was looking at the cases and what they said. Okay, so look, let me just let's just turn it one, and then I'm going to stop on this. Let's just turn it one page further. Imagine I've written this book and I've never written anything about proportionality, not a word. And then some smart DPhil student comes along and says, he starts doing digital searches and does what I did by chance and comes across the word proportionality. And then he or she does what I did, which is said, whoa, that's quite interesting. Let's do a digital search in the English report for any case about proportionality. And then that smart, he or she, that smart doctoral student says, Craig has made this huge mistake. I mean, he's written this book about English administrative law, and yet there's this body about proportionality, which is not even mentioned. What's the answer? I mean, I don't think there is an answer. I repeat, nothing about that chapter is determinative in and of itself about the status of proportionality as an independent ground for review in modern administrative law. At the same time, I don't think we should close our eyes to the historical record, the statute, and the common law. I think I've said quite enough.
Wonderful. Thank you very much.